Okay, let's dive in because when you're buying or selling a house, this whole closing process, especially title and escrow, it can feel like a black box, you
Oh,
know?
absolutely. It's got its own language, its own potential pitfalls. It's definitely where things get serious and, frankly, where mistakes can cost you.
Exactly, which is why we're doing this deep dive today. We're looking at a really insightful YouTube video. The title is Five Title and Escrow Traps. We interview an insider.
Right. And that video comes from Don and Susie Carsteth. They run Rethinking Real Estate up in Lake Tabbs, Washington. Good stuff.
Yeah, and the insider they interviewed, that's Lisa Schultz. She's a senior account executive, assistant VP at Chicago Title Company down in Tacoma, so she's really in the trenches.
Definitely brings that practical, on-the-ground view. She sees what actually happens day to day and, crucially, what goes wrong.
So our mission here is pretty straightforward. We're going to pull out the key insights from Lisa's conversation for you. Cut through the jargon, bust some common myths, point out the mistakes people make.
And, maybe most importantly, cover those fraud prevention tips, because that's where things get really scary.
Yeah. Think of this as like your quick guide to understanding this crucial part of the deal.
And Lisa really started with the basics, something that confuses a lot of folks. Just what is the difference between title and escrow? People tend to mash them together.
Right. They sound similar, maybe, but they do totally different jobs. She had that great analogy for title, called it doing a book report on the property.
Yeah, that's a perfect way to think about it. Title is all about digging into the property's history. The title company goes back, sometimes way back, looking at the chain of ownership.
Checking who owned it when, looking for gaps.
Exactly. And checking for liens, like old mortgages, unpaid taxes, contractor liens. Also easements, rights someone else might have to use part of the property, boundary issues, anything that could cloud the ownership.
So all that research is basically for make sure that when you buy it, nobody else from the past can pop up and say, hey, that's actually mine.
Precisely.
Yeah.
And the result of all that digging is the title insurance policy. That policy is your safety net. It says, look, we checked the history up to this point, and we insure you against claims from before you bought it.
Like the classic Uncle Harvey left me this house in his will situation.
Exactly that. Title insurance protects you from those historical claims. And importantly, that policy stays active for as long as you own that property.
Okay, got it. Title is history check plus insurance for the past. So then escrow. If title is about the property, escrow is about the deal itself.
That's it. Escrow is the neutral middleman for the transaction. They hold all the important stuff, the buyer's money, the seller's signed deed, the lender's documents, everything needed to close the deal.
They're like the referee, making sure both sides follow the rules of the contract.
Kinda, yeah. They follow the instructions laid out in the purchase agreement to the letter. They make sure the buyer pays, the seller signs over the property properly, the lender funds the loan. Then they release the funds and record the deed.
Making sure the actual transfer happens legally and everything lines up before the money moves or keys change hands.
Exactly right. They manage that whole transfer process. And unlike title insurance, which is long-term, escrow is just for the duration of the contract. Once the deal closes, escrow's job is done.
Title. Long-term history protection. Escrow. Short-term transaction management. Makes sense.
And Lisa threw in a quick but important note there, who actually pays for that title policy. It's different depending on the state, so you always need to check local customs.
Good reminder. Real estate is always local, right?
Definitely. Now, speaking of what people get wrong, Lisa pointed out maybe the biggest misconception isn't exactly a myth, but just a general lack of understanding about what title and escrow companies really do.
Yeah, people probably think they just, hold the earnest money deposit in a safe somewhere.
That's the common image, yeah. But she really emphasized they do way more. Escrow isn't just passively holding funds. They are actively creating the legal documents needed to transfer ownership. That's a huge part of their job.
Creating documents, like the deed itself.
Deeds, settlement statements, other legally required forms. And they have a serious legal duty, mandated by the state, to handle that transfer impartially. No playing favorites between buyer, seller, lender, anyone. Strict neutrality is the rule.
And she busted that myth about the earnest money check too, right? The idea that they just hang on to it for ages.
Oh, yeah, that was interesting. She said, at least in Washington where she works, the law actually requires them to cash those earnest money checks very quickly, often within 24 hours.
Really? Why so fast?
To verify the funds are good right away. It's not just symbolic. They need to confirm that money is real and available early in the process. It makes sense when you think about it.
Yeah, it does. And these days, it's probably not just checks they're handling, I assume. wires, cashier's checks.
All of it. They manage the whole flow of funds, however it comes in, alongside creating those critical legal transfer docs.
Okay, so neutrality is the legal standard. But Lisa added a really important but there, didn't she? A warning, almost.
She did. While the official role is neutral, she pointed out that, in reality, some escrow companies might not be truly independent. They might be owned by or affiliated with a builder, or maybe lean towards representing the buyer or seller more closely.
Huh. So even though the function is neutral, the company itself might have an angle.
Potentially, yes. And that's why she was so adamant about this.
Mm-hmm.
You have to read your escrow instructions. Don't just glance at them. Understand who the escrow company is actually working for, or if they have any affiliations disclosed in that paperwork. It matters.
That's huge. Read the fine print, understand who's who in your transaction. Okay, shifting gears a bit, Lisa gave some real warnings, like public service announcements, about common mistakes that can completely jam up or delay a closing.
Oh, for sure. And often, it's the really basic stuff that causes the biggest delays.
Like what's number one on the hit list?
Just not filling out the initial paperwork they send you. Right at the start, title and escrow send out questionnaires to both the buyer and seller. These aren't junk mail.
What's in them?
Authorizations. They need your okay to order things like payoff amounts for existing mortgages, your insurance details, HOA contact info and statements, all of the stuff required to clear title hurdles and prep the closing docs.
So if you don't send that back quickly,
the whole train stops. They're literally waiting on you for permission and info. Lisa's advice was blunt. Fill it out right away. If you're confused about anything on it, just call them. Don't guess, don't ignore it.
Makes total sense. They can't move forward without your input. Okay, what was the second big one? This sounded a bit less obvious.
Being out of town for closing or near closing and not telling anyone.
Wait, but I thought everything was digital now. Can't you just DocuSign everything from a beach somewhere?
Well, yes and no. Lisa acknowledged that digital signatures, authentic sign, are super common, especially between you, your agent, and your lender. But
there's always a but.
There is. Escrow and title have to deal with county recorder offices, government entities, and guess what? A lot of those places still require old-school wet signatures, pen to paper.
Seriously? Even now? Why?
Yeah. It's often driven by the county's recording requirements. The official property record system might just not be set up for purely digital filings yet, for certain key documents, like the deed itself.
Wow. Okay, so physical signatures are still a thing.
Definitely. Plus, many crucial closing documents need to be notarized. The notary has to positively identify you. That can sometimes be done remotely via video now, but they still need to see you and verify your ID. And sometimes, especially for those wet sign documents, an in-person notary is required.
Which brings us back to being out of town.
Right. Lisa told that story about a deal with buyers scattered literally across the globe. South Africa, the Philippines, Pennsylvania. It worked because the escrow company knew well in advance where everyone was going to be. They could arrange for mobile notaries, international document couriers, whatever was needed.
So the problem isn't being away, it's the surprise factor.
Exactly. You have to communicate your travel plans to your escrow officer so they can make the necessary arrangements. Don't just disappear.
Communication, communication, communication.
Yeah.
Okay. And that notary requirement, verifying ID, that led directly to the third mistake she mentioned. Another one that seems almost too basic, but apparently happens all the time.
Oh, yeah. Showing up to sign your closing documents with an expired ID, or no valid ID at all.
You're kidding. People do that.
All the time, according to Lisa. The notary has a legal obligation to verify your identity using a current, valid, government-issued photo ID, like a driver's license or passport. They can't accept an expired one. She mentioned people saying, oh, this is all I have, or it just expired last week. Doesn't matter.
No valid ID, no notary stamp.
No signing, no closing. It grinds everything to a halt over something completely avoidable. Check your ID expiration date before closing week.
Okay, those mistakes are frustrating. They cause delays. But then Lisa pivoted to something much, much more serious. Fraud. That part of the conversation was sobering.
It really was, and she spent a good chunk of time on it because the potential losses are devastating. The big one they see constantly, wire fraud.
Right. How does that usually work? It sounds sneaky.
It's incredibly sneaky. Criminals actively target real estate deals because they know large amounts of money are moving. They hack into email accounts, could be the buyers, sellers, agents, even the title companies sometimes, or intercept communications.
And then what?
Then, usually right before closing, when the buyer is expecting to get wiring instructions for their down payment or closing costs, the criminals send a fake email. It looks exactly like it came from the escrow company with wiring instructions, but it directs the money to the fraudster's account.
Oh, wow. And the speed. She mentioned how fast that money disappears. That was chilling.
It's terrifying. Lisa said once that wire transfer goes through to the criminator's account, the money can be moved out of that account and often out of the country in less than 18 minutes.
18 minutes. That's almost unbelievable. And once it's gone.
It's basically gone. Recovery is extremely difficult, often impossible.
So prevention is everything. What were Lisa's absolute top tips to avoid becoming a victim?
Her number one piece of advice, and she was very direct about this, assume your email is compromised. Just operate from that standpoint. Be super careful what you post on social media too, shouting, just bought a house, or under contract. Basically puts a target on your back for these criminals.
Makes sense. Keep it low-key. But the big one was about the instructions themselves, right?
Yes. Never, ever, ever trust wiring instructions that you receive only by email or text, period. Doesn't matter how legitimate it looks.
So what's the safety step? How do you confirm?
Verbal verification. Always. You must call your escrow officer directly. Use a phone number you know is correct. Get it from their official website or from paperwork you received before the suspicious email. Do not use a phone number listed in the potentially fraudulent email.
Okay, call a trusted number, and then what?
Verbally confirm every single detail of the wiring instructions. Account number, routing number, bank name, beneficiary name. Read it back, make sure it matches exactly what they have. Lisa told that story about the client who didn't have voicemail, so they specifically scheduled a time to call in for that verbal check. It's that critical.
And she said if a company doesn't require verbal verification...
That's a massive red flag. A reputable escrow company will insist on verbal confirmation for wire transfers. If they don't, you should be very wary.
Wow, okay. Assume email isn't safe, call a known number, verify every detail verbally. Got it. What other types of fraud did she warn about?
Seller impersonation fraud. This one's apparently on the rise.
Someone pretending to be the owner to sell a property they don't own.
Exactly. They often target properties where the actual owner lives out of state or even overseas, figuring they're less likely to be monitoring the property closely, maybe vacant land or rental.
How do they even start that process?
They might list it online, maybe for sale by owner, to avoid agent scrutiny initially. They find a buyer, get it under contract using forged documents. Their main goal is often just to get that earnest money deposit released to them quickly and then disappear.
And she shared a real-life horror story about that too, right?
She did. A case involving a supposed seller living in Germany. They got the property under contract and somehow convinced the parties to release the $50,000 earnest money deposit early.
$50,000?
Yep. Released to the fake seller who promptly vanished.
Yeah.
Never heard from again. $50K is just gone. It really highlights how important verifying the seller's identity is, especially for remote owners.
Unbelievable. It makes you really value the checks and balances good professionals put in place. And the last type of fraud was really sad. Elder fraud.
Yeah, that one's tough. Preying on vulnerable seniors. Lisa describes scenarios where someone might approach an elderly homeowner, maybe someone struggling with upkeep. They offer a bit of quick cash, $10,000, $15,000 maybe.
He's helpful on the surface.
Right, but in exchange, they trick the homeowner into signing complex, predatory documents they don't understand, like a really long-term listing agreement with terrible terms, or even documents that start transferring ownership or equity without them realizing the full implications.
And she tied this to the aging population, didn't she?
Yeah, the boomer generation getting older. Sometimes family needs to step in more with finances, or, sadly, individuals might just become more susceptible to these kinds of high-pressure tactics or confusing schemes. It's a growing concern.
Which actually leads pretty naturally into another tool often used in these situations or when people travel, power of attorney, POA.
Right. A power of attorney, or POA, is just a legal document where one person, the principal, gives another person, the agent or attorney, in fact, the authority to sign legal paperwork on their behalf.
Like saying, you can sign my name on these specific documents.
Pretty much. And they're super common in real estate for lots of reasons.
Lisa mentioned a few.
Yeah, like helping aging parents who maybe aren't comfortable or able to handle the signings anymore. Convenience for couples where one person travels a lot for work. And very frequently for military folks who are deployed or stationed overseas.
Makes sense. They're practical tools. But, surprise, surprise, she said using them can go wrong too.
Absolutely. Another potential pitfall, the single biggest mistake she sees, using the wrong kind of power of attorney. Specifically, trying to use a general POA for a real estate deal.
What's the difference? Isn't a POA just a POA?
Not when it comes to real estate.
Yeah.
A general POA might give broad authority for financial matters, banking, etc., but it often doesn't include the specific legal power required to buy, sell, or take out a loan on real property to encumber property, as they say.
Ah, so you need special wording.
You need very specific language in that POA document that explicitly grants the agent the power to conduct real estate transactions. Without that specific language, the POA is basically useless for closing the deal. Lenders are especially strict about this. They have to review and approve any POA being used to sign loan documents.
That's why Escrow asks for a copy of the POA up front then, to check the wording.
Exactly. They need to see it has the required real estate powers. Lisa even mentioned that some escrow companies might be able to help prepare a specific POA tailored to the transaction, but they need to understand the situation first.
And military POAs from JG.
She said those are often fine if they contain the necessary specific language for real estate. They still need to be reviewed.
So the takeaway is, don't just grab any old POA form. You need one that specifically covers real estate transactions and get it checked early.
Precisely. Get the right POA with the right words, or you're going to hit a wall at closing.
Wow, okay, that was a lot, but incredibly useful. We've really unpacked title and escrow, the difference between them, busted some myths, flagged those common closing delays like paperwork and travel.
Covered the really serious fraud threats, wire fraud, impersonation, elder fraud, and those crucial prevention steps like verbal verification.
And clarified how to use powers of attorney correctly. All distilled from that interview with Lisa Schultz.
It really drives home her point, doesn't it? That hiring experienced, knowledgeable title and escrow professionals is just so worth it, as she put it. They're your safeguard.
They absolutely are. They navigate these complexities and protect you from costly errors and outright theft.
But, as Lisa also made clear, you can't just hand it all over. Your own vigilance, especially with communication and verifying things like wire instructions, is absolutely critical too.
Yeah, which leaves us with a final thought maybe. In this world where tech makes everything so fast, so convenient, but also enables fraud that can wipe out your savings in, what was it, less than 18 minutes?
Less than 18 minutes, yeah.
How does that speed, that ease, change our own personal responsibility, our need to just pause, double check, be absolutely certain before we click that button or send that wire for one of the biggest financial deals of our lives?
That's a really good question. Something to chew on, for sure, well beyond just real estate.
Indeed. Well, thank you for joining us on this deep dive into the essential world of title and escrow. We really hope pulling these insights from Lisa Schultz helps you feel more prepared for your next transaction.
And thanks again to Don and Susie Karstead of Rethinking Real Estate, and of course, Lisa Schultz from Chicago Title Company for sharing such valuable practical knowledge in their video.